Question 106. If a borrower fails to make his monthly mortgage payment, a late payment fee can be imposed. A. 1 day after the deadline. B. 10 days after the deadline. C. 1 month after the deadline. D. No late payment fee is allowable. Correct answer is B. 10 days after the deadline. While the exact number of days can vary depending on the specific loan agreement, a common grace period for mortgage payments before a late fee is imposed is around 10 to 15 days. It's usually not 1 day, and it's definitely not a full month. The mortgage documents will specify the exact grace period and the amount of the late fee. Question 107. If a broker discovers ambiguous or difficult to understand language in a contract being negotiated, he should A. Attempt to exploit any discrepancies for the benefit of his client. B. Settle the discrepancies after executing the contract. C. Settle the discrepancies before executing the contract. D. Abandon the transaction. Correct answer is C. Settle the discrepancies before executing the contract. In the best interests of both the buyer and the seller, the broker should try to resolve ambiguities prior to executing the contract. If they find ambiguous or unclear language in a contract, they should address and resolve those issues before the contract is signed. This prevents misunderstandings, disputes, and potential legal problems down the road. Trying to exploit discrepancies or waiting until after signing is unethical and potentially harmful to the client. Abandoning the transaction is an extreme measure and usually not necessary. Clarifying the language is the proper course of action. Question 108. If a purchaser asks the listing broker for permission to move into the property before the sale closes, the broker should A. Prepare a temporary lease for the buyer. B. Allow the buyer to move in. C. Allow the buyer to move if consent is obtained from the owner. D. It is impossible under any circumstances for the buyer to move in before the sale closes. Correct answer is C. Allow the buyer to move if consent is obtained from the owner. Since the property remains in the seller's possession until the sale closes, the seller would have to provide permission for the buyer to move in. The broker cannot simply allow the buyer to move in. A temporary lease agreement, option A, might be a good idea to protect both parties, but it's not the best way to handle this situation. The key is that the owner must agree, and the broker should facilitate that agreement and ensure proper documentation, whether it's a formal lease or some other written agreement outlining the terms of the early occupancy. It is possible for a buyer to move in before closing, but it requires the owner's permission. Question 109. Which of the following is not appurtenant to the land? A. Trees. B. Lighthouse. C. Commercial signs. D. Fences. Correct answer is C. Commercial signs. Something that is attached or affixed to the land, either by nature or man, is said to be appurtenant to it. While trees and fences are clearly attached, and a lighthouse is a separate structure, the key distinction with commercial signs is their status as trade fixtures. Trade fixtures are items attached by a tenant for business purposes and are generally considered personal property, not fixtures appurtenant to the land. Question 110. The following can be compared to a sandwich. A. Purchase contract. B. Sales contract. C. Oral contract. D. Subleasing contract. Correct answer is D. Subleasing contract. A sublease is like a sandwich. The original lease is the bread. The sublessor, the original tenant, is the filling, and the sublessee is the other slice of bread. The original tenant, now sublessor, leases the property to a new tenant, sublessee. But the original lease between the landlord and the original tenant remains in effect. So there's a layer of leasing happening within the original lease agreement. It's also called a sandwich. Question 111. When a mortgage debt is paid in full, releasing the property from a lien, the mortgagee must provide the mortgager with A. Certificate of discharge. B. Sheriff's deed. C. Documentation of release. D. Payoff bonus. Correct answer is A. Certificate of discharge. Another name for the certificate of discharge is satisfaction of mortgage. The mortgagee must record this discharge certificate within 30 days or incur a $500 penalty. Question 112. A percolation test would likely be used for A. Mineral deposit measurement. B. Building a home septic tank. C. Oil well maintenance. D. Determining an air quality index. Correct answer is B. Building a home septic tank. A percolation test is used to determine the absorption rate of soil. This is crucial for determining the suitability of land for a septic system. The test helps ensure that the soil can properly drain wastewater and prevent contamination. The results of such a test are required to properly design a septic system. Question 113. A potential buyer signs an option contract with an owner, properly backed by consideration. The owner dies a week later. The option is A. Void B must be renegotiated, C. Unenforceable, D. Binding on the owner's heirs. Correct answer is D. Binding on the owner's heirs. An option contract, when properly supported by consideration, is generally binding on the parties involved. The death of the optioner, the owner in this case, does not automatically invalidate the option contract. The option remains enforceable against the owner's estate or heirs, who are now obligated to honor the terms of the contract if the optionee, the buyer, chooses to exercise it within the specified time frame. Question 114. The following is true about open mortgages. A. Has overdue payments and is available for foreclosure by the lender at any time. B. Describes a loan secured by a property that can be paid off without penalty at any time before the loan's maturity date. C. Has a very low threshold of creditworthiness needed to open it, so almost any borrower can qualify for it. D. Both A and B. Correct answer is D, both A and B. An open mortgage allows the borrower to prepay the principal balance, either partially or entirely, without penalty. This is the defining characteristic of an open mortgage. Question 115. When such terms as adequate, valuable, or sufficient are mentioned in a contract, they usually refer to A. Character of the offeror, B. Availability of funds, C. Attorney fees, D. Consideration. Correct answer is D. Consideration. In contract law, adequate, valuable, and sufficient often describe the consideration exchanged between the parties. Consideration is something of value, a promise, an act, or forbearance that is exchanged between parties to a contract. It's a necessary element for a contract to be legally binding. The terms adequate, valuable, and sufficient suggest that the consideration being exchanged is of enough value to make the contract enforceable.